I'm Katie, and I'm currently taking the Real Estate Pre-License course through Metro Brokers Academy School for Real Estate. I want to invite you to study with me on my channel. We will review all the chapters individually, as well as the vocabulary you need to know within each chapter. So don't forget to like and subscribe at the end. Without further ado, let's move on to today's topic. State Exam Prep, Ownership Review, with Katie Landers Does Real Estate. Before we get started, let's take a look at today's outline regarding ownership and all the things we will be covering. You can find this outline in the description below this video. After we review this chapter, you can also look forward to a chapter quiz and vocabulary. So don't forget to subscribe. Let's get started. Ownership. The concept of ownership comprises the bundle of rights. The term bundle of rights describes a set of legal rights associated with ownership of real property. The bundle is made up of 5 different rights: the right of possession, the right of control, the right of exclusion, the right of enjoyment, and the right of disposition. Today we will review 3 categories of ownership: severalty ownership, concurrent ownership, and other forms of co-ownership. Types of property ownership. Severalty ownership, or tenancy and severalty, is an estate owned by one person or a single legal entity, which is also called severalty ownership or sole ownership. Ownership is severed from everyone else. Depending on the state, sometimes a spouse's signature is required for the property to be transferred to waive courtesy, dower, or community property rights. For corporations, documents should be signed by authorized officers and include the authorizing resolution and corporate seal. Concurrent ownership. When 2 or more people simultaneously own rights in the same land, they are said to be co-owners or concurrent owners. There are 3 different types of concurrent ownership: tenancy in common, joint tenancy, and tenancy by entirety. Tenancy in common. A form of concurrent ownership where co-owners hold an equal or unequal undivided interest without the right of survivorship. Created in a deed or will and occasionally created by court or statutory action. It imposes the fewest restrictions on the co-owners. Each holds separate title with separate estate. A co-owner does not own a specific physical portion of the property, but an undivided interest in the whole. Interests do not have to be equal. Each co-owner can mortgage, will, or otherwise sell their share without the consent of the other owners, as long as their rights are not affected. Tenancy in common is presumed if there is no indication of how the title will be held. Tenancy in common is inheritable but does not have the right of survivorship. Now let's talk about joint tenancy. Co-tenants jointly own a single estate. There is only one title, and it does have the right of survivorship. It can only be created through deed or will and not involuntary by court action or statute. To create joint tenancy, 4 unities have to be present. We call them PIT. And any of these is destroyed, joint tenancy is terminated. You have possession, interest, time, and title. Possession is when each tenant has an undivided interest in the property as a whole. They have a right to use and enjoy the whole property. Unities of possession is the only one shared by tenants in common and joint tenants. For interest, they must hold equal interest in the same type of freehold interest. Time, they must acquire their interest at the same time. Title, only one title if there are 3 or more co-tenants and one of them conveys an interest, the joint tenancy will terminate for that share. A partition suit may be filed when an agreement on a method of dissolving the tenancy cannot be reached. Now let's talk about tenancy by entirety. A special form of joint tenancy between husband and wife. Both own an equal undivided interest in the entire property with the right of survivorship. Any instrument to convey or transfer an interest in the property must be signed by both spouses. Old English common law, where a husband and wife become one person and cannot own anything individually. Effectively, each spouse owns the entire estate. It has the same features of joint tenancy, including survivorship. However, it differs in 3 ways. 1. It is exclusive for husbands and wives. 2. Neither spouse can sell, mortgage, or lease his or her interest without the consent from the other. And 3. Creditors cannot force the sale of half the property to satisfy either spouse's personal or business debts. Other forms of co-ownership. Community property. Applies only to husband and wife as long as they are legally married. It provides each spouse with a 1/2 interest in any property acquired during the marriage. Property acquired before or gifts and inheritance are considered separate property. Georgia is not a community property state. Tenancy and partnership. A form of concurrent ownership in which title is held by either a general or limited partnership and a registered trade name. General partnership. A type of partnership which allows each partner to participate in the management of the business but holds the partners jointly and personally liable for obligations incurred by the partnership. Limited partnership. A partnership made up of general and limited partners. A general partner has the responsibility of managing the business of the partnership and is held liable for its obligations. Limited partners are investors who do not participate in the management and are liable only to the extent of their investments. General partners carry on the management of the business and have the same obligations of a general partner. Limited partners are essentially investors and have no management involvement. A joint venture is a limited or general partnership established for a particular business project. Limited liability company. A unique form of ownership not classified as a corporation, but an association similar to that of limited partnership. Management responsibilities are vested in its members, and members are not personally liable for debts of the limited liability company. Members are not stakeholders, and therefore profits are not taxed at the corporate level. Now let's talk about trusts. An arrangement in which title to property is held by a trustee on behalf of a beneficiary. Trust is created when a property owner, the trustor, places the title to the property in the hands of someone else, the trustee, for a third-party beneficiary. It is created through a written instrument that may be a formal trust agreement, a will, or a deed. You have Testamentary Trust, Living Trust, Land Trust, and Real Estate Investment Trust. Testamentary Trust is created by will after the owner's death. Living Trust is created by agreement during the trustor's lifetime, possibly as a way to avoid probate costs or minimize tax liabilities. Land Trust is created by a trustor who will also be the beneficiary and who will retain control over management of the property. Real Estate Investment Trust, also known as REIT, must have a minimum of 100 investors, beneficiaries, to qualify for income tax benefits. It's managed by a board of trustees who invest in real property or in mortgage loans. Pays no income tax as long as 90% of income is passed through to beneficiaries each year. Now let's talk about syndicate. This is not a legal form of ownership, but a descriptive term for a group of individuals or firms who get together for the purpose of investing or dealing in real estate. Condominium ownership allows multiple owners to hold a fee simple title to their individual unit. All other parts of land and buildings are called common elements. Owners are tenants in common. Each owner's undivided interest in common elements, common interest, may be determined by total number of units or square footage. They must abide by covenants, conditions, and restrictions, CC and Rs, that govern how common area and units can be used. The Georgia Condominium Act allows a 7-day right of rescission for buyer of a new unit. Master deed is the principal conveyance document used to create the condominium. It includes legal description and thorough description of the entire property. Declaration includes description of each unit, percent of interest in common elements that attach each unit, description of common areas and uses, and plat, detailed site plan. Bylaws. They establish the framework for forming of a homeowners association. Developer must turn over management to association when 80% of units are sold or after 3 years from date of declaration was recorded. Timeshare. Another application of condo ownership when a unit is sold to multiple owners for a specific period of time. Georgia Timeshare Act also allows a 7-day rescission period. Trust funds must be deposited in escrow sales against agent. Trust funds must be deposited in escrow sales. Agent must be licensed as real estate brokers, and advertising must comply with Fair Business Practice Act. Cooperative ownership. When multiple unit building where a corporation holds title to the land and improvements, each unit owner buys stock in the corporation for the exclusive right to use a particular unit for the life of the corporation. The owner gets a proprietary lease.
And that's all I have for today's topic, folks. Thank you for studying with me, and don't forget to like and subscribe for more content.